Ma'am? Ma'am?
Ma'am.
Are you trying to see somebody at the jail? Ready?
Good afternoon, Your Honor. I feel like you're looking at us. Are you looking at us or are you talking to Mr. Adams?
No, Mr. is not in here. No, talking to you. We're just waiting on y'all.
Okay, well, we are ready with Mr. Wood and Mr. Brenner. Mr. Brenner,
All right, Mr. Bruner, step on up. All right, this is cause number CR 2041 and 42, State versus J. Michael Bruner. Mr. Wood, what are we doing today?
Judge, I've spoken with Mr. Bruner yesterday, the day before yesterday, and again today. My hope was that we might have been able to resolve this, but it doesn't look like that's going to be the case. At this point in time, Judge, we're just going to have to set this thing for a trial on his incompetency or competency, whichever you want to call it.
A trial on competency?
Correct.
Okay.
We've already done that.
Is that a jury trial request on competency, or is this a hearing to question and test Dr. Ingram's findings?
That's correct, Judge.
Which one?
It's the latter.
So you want Dr. Ingram to be, you want to subpoena Dr. Ingram or have him brought before the court, and you want to test him on his findings?
Correct.
Okay, so you oppose the report finding him to be competent?
That's correct, Judge.
Okay. Stand by for just a second.
Mr. Brenner.
Sound like I'm standing there.
Mr. Brenner,
What?
step up to the
Oh,
podium.
what?
Mr. Brenner,
What?
doesn't look good for you, sir.
Oh, then, what do you want to do about it? Nothing.
I'm just saying the judge is watching you.
Not paying them, Judge. What are you talking your crap for? The other day you said 2 years probation, they changed it. No, but I ain't gotta stand up here with you. Why would I stand up here with you? I could lie.
Bailiff, go ahead and take Mr. Bruner back to his cell.
Who's bailiff?
Mr. Wood, would you be available on October 28th? We've got Dr. Ingram coming on another case for the same issue.
Judge, I don't,
Be 2 weeks.
we're leaving that next day, Judge, to go to Pittsburgh, leaving on 31st. I mean, we can set it for then, that's fine.
Okay. All right, court will set Mr. Bruner then for evidentiary hearing on the motion regarding competency. And we'll set that for 10 a.m. on 10/28.
Judge, is that the 28th or the 26th? I don't recall.
28th.
Thank you.
28th is Saturday.
Of course. Yeah, I wasn't thinking through that. Thank you, Judge.
All right, we ready on Mr. Lopano? Is he present?
Judge, he is present, and we're ready as far, I don't know if Ms. Hazel's there as well, but we're ready as far as the motion to reinstate the bond.
Judge, and the state is unopposed to that. I'd spoken to Mr. Wood about getting an order. I don't believe we ever have, but the state is unopposed to reinstating Mr. Lopano's bond such that he can be out in the free world, working with Mr. Wood and his defense, whatever he needs to be doing. We don't believe he's a threat to the community or anything like that at this point. So we would be unopposed to reinstating, I believe it was a $20,000 PR bond. Is that correct, Mr. Wood?
It's either a $50,000 PR bond or a $25,000 PR bond. And in our motion, Judge, we left it up to the court's discretion on which one you would like to do. But obviously, I think it was initially a 50 and then it went down to a $25,000 PR, if I'm not mistaken.
All right, before I take that issue up, what's the announcement on docket call?
Judge, at this, obviously, Mr. Lopano was in Cameron County for some time. I had met with him one time to start kind of discussing the case with him. At that time, though, I hadn't had all the discovery at my disposal, and I hadn't had a chance to go through it. I've subsequently, obviously, since he's been in Cameron County, had an opportunity to go through it, but I've not had a chance to go through it with Mr. Lopano due to a number of different reasons. But I've also not had a great opportunity to speak with Ms. Heisel about this in detail. I have talked to her a couple of different times about the case. I think we're trending in that direction. And I think we agreed this morning if we could have reset it for a new docket call, then hopefully we can kind of be a little bit more prepared to give the court an answer. I don't even have an offer on the case, so there's nothing that I could really, talk about regarding that. So if that would be okay with the court, that's what we would request.
So there's no offer from the state on this one?
Judge, I do believe there is an offer. It may not be in our portal where Mr. Wood can see it. Off the top of my head, I don't remember what it is. However, I did talk with Mr. Wood this morning and discussed with him that the fact that Mr. Lopano has handled his business in other counties may affect that offer and may necessitate a new offer from the state. So even though, Judge, I know it looks like this has had a bunch of settings, but Mr. Lopano has only been here for one of those settings. So the number on the docket kind of is misleading. We've, like Mr. Wood said, not had any substantial discussion or review of this case.
I think we touched upon this before, but I want you to remind me and explain it to me again. How was it that Mr. Lopano ended up in Cameron County? And so the question I want answered is, did Mr. Lopano commit a new crime while on bond in this case that got him sent back to Cameron County? I understand through reading the motion that it was a motion to revoke. He must have been on probation in Cameron County, must have committed this or alleged to have committed this crime here. And I don't know if he's been revoked on new charges or old charges. Tell me how he went into custody in Cameron County, which is why he hasn't been here.
Judge, there were no new charges brought against Mr. Lopano. It's my understanding that the basis of the revocation in Cameron County, it did not even include these new charges in Van Zandt County. In other words, he's not pled true to the charges in Van Zandt County, but there were other technicals, I think failure to do community service, not pay his fees, et cetera, that led to his revocation over in Cameron County. He did subsequently got a time served offer on that case in Cameron County. Was there for obviously for a while, and then returned back to Van Zandt County because in the interim, it's my understanding that Van Zandt County went off his PR bond, and therefore the hold was placed on him because he couldn't report to pretrial, although he had been reporting. And I talked to Mr. Waddell this morning to make sure of this, and he had been reporting and doing everything like he had supposed to have been doing here in Van Zandt County before the Cameron County warrant hit him. And at that point in time, he obviously could not fulfill his obligations to be over in Van Zandt County. So that's the basis and kind of why we are where we are.
So he wasn't revoked for failure to report in Cameron County, is that right?
Was that?
No.
No, not from my understanding, Your Honor.
Okay, and so state, even despite the fact that he's been revoked in another county and he served all of his time there, you're still telling me that you think it's a good idea to put him on bond here, on a PR bond?
Judge, it's to our knowledge, Mr. Lopano has always been here absent when he couldn't be here because of his incarceration in another county. Additionally, the children are protected, so we don't have a safety concern for them. Actually, it's a single child victim in this. And so based on that, we our understanding is the only reason for the forfeiture was because he was in another county. So we're basically just agreeing to reset back to his status before that happened.
All right, the court's going to set Mr. Lopano for docket call on November 30th. And the court will grant the request to reinstate the personal bond.
Thank you, Your Honor.
Thank you, Your Honor.
Yes.
Judge, you said November 30th.
Correct. And that'll be at 9 a.m. if he's on bond.
Okay. I believe that's all I have for this afternoon, Judge. I could be.
Sir. Yes, sir. Thank you.
Thanks.
Yeah. Mr. Manning, are you ready?
Judge, I am. Just real quick on Mr. Morris. Judge, I show we were supposed to, we were set for a plea back in September. We were set that plea to today for my client and I to review some discovery. We've done so. We were ready to go forward with the plea today, but it looks like I had a paperwork situation. I don't know if that was on my end or what, but we don't have paperwork at this time. So we kind of spoke to Mr. Morris. He's fine with resetting the case to another docket. It's for time. And my understanding is that Van Zandt County is requesting that he stay in Van Zandt County to continue cooking. So I don't think it's gonna make much difference on our end. But if we need to get a quicker reset, we can do that. or we can try to get it done today if the court prefers.
So what are you asking me to set it for?
If we can reset it for a plea, I'll make sure I get the paperwork, the updated paperwork. I have the old paperwork, I don't have the updated paperwork for today. And I'll make sure I get that in advance of next hearing.
Are you available October 26th?
Yes, Judge.
All right, court will set Christopher Morris and CR 286 for plea on 10/26 at 1:30.
And I will execute a reset in that fashion. May Mr. Morris be excused.
Yes, sir. And Deputy McLeish, I'll let you know that I have Mr. Knoll, Mr. Brian Schmidt, and Miss Mihal. That's Ann
She's
Thompson.
actually not present right now, Judge.
Okay, all right. Is Mihal Law, is that Miss Ann Thompson?
Yes, Judge, Mihal Law is Ms. Thompson.
Judge,
Yes, Your Honor. What can I help you with?
Oh, I was just letting you know that I've got Brian Schmidt, Kurt Knoll, and what I think allegedly is Miss Thompson in the, it's Mihal Law, the waiting room.
Yes, sir. I'm actually pulling Mr. Schmidt's line right now.
That's fine. I was just gonna let you know that they're in the waiting room.
Thank you, sir.
CR 21-140, State versus Andrea Cherie Pullings. Ms. Pullings, if you'll raise your right hand. Ms. Pullings, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you can put your hand down. Your name is Andrea Cherie Pullings, is that right? And Ms. Pullings, are you a United States citizen? Do you read, write, and speak English? Have you ever been diagnosed with any type of mental condition? In this case, you're represented by your attorney, Mr. Mitch Adams. Are you pleased with his representation of you? Do you feel like you've had enough time to discuss your case with him and get all of your questions answered? Is there anything about the paperwork today that you've read and signed that you do not understand? And Mr. Adams, do you believe Ms. Pullings to be competent today? And have you explained to her her legal and constitutional rights and also the advantages and disadvantages of a deferred adjudication plea? And do you believe she understands? Ms. Pullings, you are charged by indictment with a state jail felony offense of abandoning or endangering a child. A state jail felony in the state of Texas carries a range of punishment of not less than 6 months or more than 2 years confinement in a state jail prison and a fine not to exceed $10,000. What that means is I approve the plea agreement before me in which the state's recommending that you be placed on 2 years deferred community supervision. If during that probation period, you violate your probation conditions and terms, and if the state files a motion to adjudicate your guilt, bring you back before the court, I could review it. And if I find that you violated any of your conditions, I could adjudicate you, which means convict you of that state jail felony offense. And then I could revoke your probation and I could put you in prison anywhere from 6 months up to 2 years, anywhere within that range, and a fine up to $10,000. Do you understand that? Understanding the plea agreement and the range of punishment, do you wish to go forward? All right, so Ms. Pullings, let me ask you then, how do you plead to abandoning or endangering a child? Guilty or not guilty? Mr. Adams. All right. Take a deep breath. Take a deep breath. You okay? I understand. I hear you. I'm just going to give you a moment to kind of get your composure because I want you to be able to hear me. Okay? I understand it can be very emotional. Are you okay? Take a deep breath. You okay? All right, Ms. Pullings. Court will accept Ms. Pullings' plea of guilt at this time. Mr. Adams, any objection to State's Exhibit 1?
No objection, Your Honor.
Ms. Pullings, has anyone threatened, forced, or pressured you to plead guilty today? Okay. Court admits State's Exhibit 1, and the court takes judicial notice of Ms. Pullings' judicial confession. Is there anything further from the state?
No, Your Honor, state would rest and close.
From the defense?
No, Your Honor, that's-
Okay, I'm gonna take just a moment and review the evidence. All right, the court's reviewed the evidence. I find that there is sufficient evidence to convict Ms. Pullings. However, the court will follow the recommendation of the state plea agreement. Court hereby defers a finding of guilt on the abandoning or endangering a child. Court assesses punishment at 2 years, community supervision, a fine of $1,500, court cost of $290, and orders Ms. Pullings to pay $535 reimbursement to Van Zandt County. Mr. Adams, does Ms. Pullings have custody of her child?
Yes, Your Honor.
Did you go through the CPS process? And so your child was returned to you? He never got taken? All right, Ms. Pullings, I hope this is a lesson to you. Understand? You're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm gonna have you step forward to be fingerprinted by the bailiff, and after that time, report to Officer Mature over here, and she'll give you additional information. Yes. Yeah, well, All right, I'm ready for the next inmate in the jail.
Judge, we're ready on Ms. Rochelle Shelton.
CR 18-337, State versus Rochelle Renee Shelton, set for pretrial. Go ahead, Mr. Manning.
Yes, Judge, we have no contested pretrial. We reached agreement with the state. We request that we reset for 10/26 for a plea.
All right, court will set Ms. Shelton for a plea on October 26th. And is that for probation or for time?
It'd be for probation, Judge.
Probation, all right. So it'll be at 1:30 then.
Thank you, Judge. And besides Mr. Harrison, that concludes my business. I don't know if you'd like for me to make a on-record announcement on Mr. Harrison. He was set for a plea today.
Well, I had that he was in Wood County Jail, but it's been marked out. I'm not sure.
That's correct, Judge. He was in Wood County Jail until last week. He got moved to Hardeman County, where he was finishing up his business, and was supposed to be moved from Hardeman County to Walker County. I was unable to get either one of those counties to connect us with a Zoom call to proceed in absentia with the plea paperwork. And so at this point in time, we're just waiting for him to circle back through Van Zandt County.
Okay, have I set you on November 30th or November 9th? I would just set him for a status of custody. Are you available on either 11/9 or 11/30?
It looks like I am here on 11/30.
11:30, all right. Court sets Mr. Brandon Lee Harrison for status of custody and plea. Well, we'll just do status of custody, and if we do the plea that day, great. For November 30th at 1:30.
Yes, Judge.
Thank you, Mr. Manning.
Thank you, Judge.
Next.
Your Honor, is Mr. Bill Stevens ready? I have both of his clients in the room.
No, I've got Brian Schmidt, Kurt, and me Hall.
Okay, I have Robert Harris in the room. Come on up, Mr. Harris.
Which one's his attorney?
That would be Brian Schmidt.
Good afternoon, Mr. Schmidt.
Hello, Judge.
All right, this is Mr. Robert Dustin Harris, CR 14494 on the state's motion to revoke. Any announcements, Mr. Schmidt?
Yes, Your Honor. I know Mr. Harris was initially denied or did not qualify for court-appointed counsel and has been reset several times attempting to hire counsel. I've been in touch with family members, and they apparently were able to hire us this morning. I've been out the last couple of days. I've been sick, but they hired us this morning. So I had Ashley send over a letter of representation, and I need to get a copy of the motion and go visit my client and speak with the state, obviously.
Okay, what I'll do then, since this is a motion revoke, I'll give you some time and I'll set this on the, I'll set it on the contested docket. We're not having a contested docket in November, but we are having on December 2nd. What I could do is set it for a contested hearing on 12/2. And then if you and the state work something out sooner than that, then I could put you on any of my other dockets between now and then if there's a resolution.
That's great. And Robert, I'll be up to the jail to see you next week. It'll be after Tuesday, but I'll be there to see you next week. And we'll talk about everything.
All right.
Okay, all right, so we'll set this for contested hearing on December 2nd until further notice.
Thank you, Judge. That's all I have. May I be excused?
Yes, thank you, Mr. Schmidt. Good to see you.
You too, Judge.
Your Honor,
Yes,
I apologize. I missed that date. Was it November 2nd?
December.
December. Thank you, sir. And Your Honor, we do have Mr. Gammons in the room for Ann Thompson.
Yes, sir, that's fine.
All right, good afternoon, Ms. Thompson.
Good afternoon, Your Honor.
All right, this is cause number CR 2164, State versus Billy Cody Gammons, and we were set for plea today.
That's correct, Your Honor.
Are we going forward with the plea?
As far as I know, we are, Your Honor.
All right, does somebody have the terms and has the paperwork been signed by the defendant and everyone?
Yes, the paperwork was all signed by the defendant and handed over to the DA's office to Laura, I believe her name, about 2-3 weeks ago.
Okay, I don't have that paperwork here. State,
Yes.
you have it?
Your Honor, I know that was brought to us. It was given over to me, and I believe I brought it to court that day, understanding that Mr. Gammons, Ms. Thompson brought it to us on a misdemeanor docket day. There was a misdemeanor that was being 1245. Let me go run it down, Judge. I gave it to the misdemeanor boys because I thought Ms. Thompson was going to be pleading it that day. So let me go find out where
Okay.
that is.
So Mr. Gammons, just have a seat and I'll call you back up in a moment once
Yes, sir.
work, okay? I will call someone else while we're waiting on Mr. Gammons.
Your Honor, I need to get some bodies. You'll give me just a moment, please.
What's going on?
Your Honor, Judge Martin.
Yes.
Mr. Adams is ready to go, sir.
All right. Who do you want to go first on, Mr. Adams?
Well, Judge, Mr. Massey is within arm's reach here. Why don't we take him first?
All right, CR 21-259, State versus Eric Massey.
Good afternoon, Your Honor. Mitch Adams on behalf of Eric Massey. We're present. We're ready to proceed. I have not yet had the time that I need to properly do my job, Your Honor. I need some additional time to visit with the state about the possibility of a negotiated settlement. I also need some extra time to review the file in this case to figure out whether or not that is going to be in Mr. Massey's best interest. And of course, to visit with Mr. Massey about all of these things to ask or find out what it is that he wants to do. So to that end, I'm asking the court's indulgence for a reset of this matter.
Any objection to arraigning him today?
No objection. Is that? You can see what kind of an afternoon I've had. No objection to the arraignment, Your Honor.
Have you seen the complaint information?
No, Your Honor. I have not.
If you'll just review this with Mr. Massey and then let me know when you're ready.
Okay, Mr. Massey. See the name there? Top, which is wrong with Eric Massey. It's my name.
It's my fault. That's what the accusing is. And I'll spend my note sheet on that. That's that there information.
Okay. Okay. Okay, Your Honor, we're ready to proceed on the record.
Okay, go ahead.
Having reviewed the charging instrument with Mr. Massey, I can represent to the court that his name is properly spelled and set forth in the complaint and information, that he is the same Eric Robert Massey here with us today, who is named in the complaint and information. Mr. Massey understands what it is he's accused of in the complaint and information. At this time, we'll enter a plea of not guilty and ask that this case be set for its first pretrial hearing.
All right, court will set Mr. Massey for pretrial hearing on November 30th. That'll be at 1:30 if he's in jail, 9 a.m. if he's on bail. State, is there any reason the information said county court at law, but it was filed with the district clerk? Is there any reason for that I need to be aware of?
Yes, Judge. Judge Winters has represented Mr. Massey about 4 times. So we filed it up here to avoid the conflict of interest. We anticipated there might be one, so we just filed it up here.
Okay.
There's nothing about this case that is aggravating that it should be within the district court's jurisdiction. It's just Judge Winters had a potential conflict.
Gotcha. All right, Mr. Massey, we'll see you back on November 30th. And if you make bond in this case, then you need to be in the courthouse at 9 a.m. On the 3rd floor in my courtroom. If you don't make bail, then your hearing will be at 1:30. You'll be in jail and we'll come to you, okay? Next.
Mr. Huggins.
Hunter James Huggins, CR 2124. Set for motion to revoke, I believe, probably the first setting.
That is correct, Your Honor. Mitch Adams on behalf of Mr. Huggins. This is the first setting. Your Honor, I've not had the opportunity yet to sufficiently perform all the duties that I need to do. In this case, I still need to review the state's motion to review that with Mr. Huggins and to attempt to negotiate some sort of compromise agreement with the state if that's what Mr. Huggins wishes to do. To that end, I would request the court set us for the first available contested revocation docket that is available.
Okay, court will set Mr. Huggins then for a motion to revoke hearing contested on December 2nd If there's a resolution reached prior to that date, then you can contact the court and we can hear it sooner.
Very good. Thank you, Your Honor.
First available is actually 10/28, but I don't anticipate you'll be ready in 2 weeks.
Okay,
Is that right?
that is correct from where Mr. Huggins is concerned.
Okay. All right, CR 16196, Tana Chitty.
Good afternoon, Your Honor. Mitch Adams on behalf of Ms. Chitty. Now, this is a revocation hearing, and it's the contested hearing, and this is not the first setting for Ms. Chitty's revocation hearing. However, in light of events of the past 3 weeks, I have not had the opportunity or sufficient time to complete what I need to do in this case. I've explained this to Ms. Chitty. She's not happy about it, but she understands that there are some things still left to do that I need to do. In order to do them the right way and to render effective assistance of counsel to her, I need to ask the court's indulgence for one more setting for her case. I think the court might have a revocation docket at the end of this month, and I can represent to the court confidently that if we're set for the revocation hearing at the end of this month, we will be ready to proceed and put her case to bed on that day.
On October 28th?
Yes, sir.
Okay. All right. Court sets Ms. Chitty then for October 28th at 1:30.
Very good. Thank you for that. Your Honor, I think that's all that I have on the afternoon docket. That being excused.
You may. Thank you, sir.
Thank you. Good to see you. Yes, very good.
Have a seat, sir.
Thank you.
All right, Your Honor, I don't know if Mr. Stevens is available yet, but I still have his people in here. I also have Mr. Michael Marley for Kurt Knoll in the room.
Mr. Knowles' clients. I haven't seen Mr. Stevens.
Okay.
So I'll go ahead and bring Kurt Knoll in.
All right, Mr. Marley, come on up, sir.
All right, Mr. Marley, we're going to give Mr. Knoll just a second to get logged in here, get his computer turned on.
Yes, Your Honor.
Good afternoon, Mr. Knoll. Looks like his audio is connecting. Let me try. Computer. All right, Mr. Knoll. You'll just unmute your computer there.
Did it again.
There we go.
Thank you, Judge.
All right, this is cause number CR 21-225, State versus Michael Paul Marley, set for pretrial.
Judge, if the court may recall, Mr. Marley was arrested last week on or whatever week it was, a couple weeks ago now, on a surety off bond. He's not seen a couple of, I think one's a 911 call that he hasn't heard. And I believe the other one is a body cam, as I recall. I don't have, at least on the portal, there was not a plea offer that had been made on the case yet. So after that, I think we'd be ready one way or the other.
All right, do you have any contested pretrial motions?
No, Your Honor.
Okay, then what we'll do is we'll set this for docket call on November 30th at 1:30.
And just for everybody's information, there is a pretrial release letter with the offer included in it in the discovery portal, or at least we show that. So Mr. Knoll, if you can't locate that, just let us know.
Okay, I looked at it actually before we had this. I didn't see it, but I'll look again.
Okay. All right, then we'll see you back on November 30th, Mr. Marley.
Thank you so much, Your Honor.
You're welcome, sir.
Judge, I think that's all I have this afternoon. May I be excused?
Yes, sir. Hope your day gets better.
I overpaid my income tax for last year, so that's good news.
That's good. You get some money back.
No, it just goes for this year.
Oh, it just goes for this year. I got you. Okay.
Thank you, Judge.
You're welcome. Have a good day.
You too.
Your Honor, I'm trying to decide what we can move forward. I have Janet McGuire in the room now. She doesn't have an attorney, or at least my docket doesn't reflect that. But I think everybody else is tied up right now. So.
Mr. Ashmore still working with Ms. Dover and Ms. Foley?
Yes, sir.
Okay. And what about Justin Cannon?
That's also one of Mr. Ashmore's. And
Okay. I didn't have him written down for Justin Cannon. Okay. Bring Janet McGuire up then. All right, Ms. McGuire, this is cause number CR 18492. You are pending a motion to revoke your community supervision. Have you requested a court-appointed attorney, or are you going to hire an attorney to represent yourself? Or are you going to represent yourself?
For now, represent myself, sir.
You want to represent yourself? You want to go into a revocation hearing and oppose the attorneys for the state?
Or ask for the time served, so we had 4 months left.
Well, I just need to know, I'm not going to negotiate with you here, and we're not going to figure out your sentence today. My question is, are you going to hire an attorney? Are you going to ask for a court-appointed lawyer, or are you going to represent yourself?
I'll ask for one, sir.
How come you haven't already done that?
I haven't had the paper.
Well, in the jail, they provide you the paper. My coordinator goes over there all the time. And how long have you been in jail?
25 days today.
It's almost a month, and you haven't requested a court-appointed attorney yet?
I thought I'd figure out, see what you'd say and then go from there.
Well, let's see what I would say. If my docket is correct, if I find that you violated your conditions of community supervision, you're looking at somewhere between 2 to 10. Let me pull up your case. I want you to have all the information you need to make an informed decision.
Yes, sir.
All right, Ms. McGuire, it says here that you appeared before the court and you pled guilty to a state jail felony offense of theft of property.
Judge, I'm looking, I think that I'm looking to see if it's a third degree or a state jail for the judgment. I'm not sure that my system says third degree as well. So let me check and make sure that the judgment reflects whether it's a state jail or a third degree.
So state jail felony here. So Ms. McGuire, you'd be looking at, if you were found to be in violation of your community supervision, the court found that to be true based on the state's evidence, you could be sentenced anywhere from a minimum 6 months to a maximum 2 years in a state jail prison that does not have parole. So do you want to hire an attorney? Do you have the ability to hire an attorney? Do you have money? Do you have assets?
Not at this time, no.
Do you want to fill out the paperwork to see if you qualify for a court-appointed attorney?
Yes, sir.
All right, Ms. McGuire, what I'm going to do is I'm going to set you for November 9th. And I want you to fill out the paperwork. It's there at the jail. All you got to do is ask for the paperwork for court-appointed attorney and they'll provide it to you. Once you fill it out, they'll send it back to my coordinator and she'll review it and then we'll contact you on whether you qualify or not. If you do, then your attorney will be appointed and you'll be given that information.
Yes, sir.
So we'll see you back on November 9th. Get that paperwork done. If I leave you today and you don't do the paperwork, no one's gonna be able to do it for you.
Right, right. Yes, sir.
All right, we'll see you on November 9th.
Thank you.
All right, let me make a phone call to check on Mr. Stevens.
Yes. Gina, get a receipt form, the yellow sheet?
Yes, I did, I'm sorry.
Shit on very bottom.
Good afternoon, Mr. Stevens.
Can you hear me now?
I can't hear you. Yes, sir.
Sorry, Judge, I'm stuck over in Athens. Judge is on a break, so I came out to my car.
Okay, well, I do appreciate it. We'll call your cases quick then. This is cause number CR 21-212, State versus Dakota Lynn Dubose for arraignment. Have you had a chance to go over the indictment with Mr. Dubose?
I have not, Your Honor. I do have the indictment with me, but I have not gone over it with my client.
All right, let me pull it up here. All right, Mr. Dubose, can you see that document?
Yes, sir.
All right, I'm gonna give you a moment to read that. Tell me when you're done, okay? And tell me when you need me to move down on the screen. All right, you've had time? Okay. Mr. Dubose, is your name spelled correctly in this document? Dakota Lynn Dubose?
Yes, sir.
Okay. Go ahead, Mr. Stevens.
Your Honor, it may please the court. My client would advise he knows what he's charged with and the nature and the consequences of the charges. Will waive reading against him in open court and enter a plea of not guilty.
All right, the court will enter Mr. Dubose's plea of not guilty into the record, finds that he's waived the formal requirements of arraignment. Court will set Mr. Dubose for a pretrial hearing. Are you available on November 30th?
Yes, sir, I am.
Okay, court sets Mr. Dubose for pretrial on November 30th. Mr. Dubose, if you make bail in this case, your hearings will be at 9 in the morning in the courthouse.
Can he hear me, Your Honor?
Yes, he can.
Okay, Mr. DeBose, I'm gonna come see you sometime next week, okay, and fill you in on everything.
All right.
All right, Audrey Jean Thompson, CR 15506 and CR 21193. Ms. Thompson set for pretrial in her burglary of a building and motion to revoke on her possession of controlled substance. Any contested pretrial motions, Mr. Stevens, on the burglary case?
Judge, not that I'm aware of, but let me be honest with you, sir. I'm looking at notes here. I was only appointed to represent her like less than 2 weeks ago. Since pretrial was so quick after I got appointed, is there any way we could reset the pretrial, sir?
Any objection from the state?
If I could get it unmuted. No, Judge. I'm aware that Mr. Knoll was on this case before. Mr. Stevens was just appointed. If he would request an additional pretrial, state would be unopposed to give him a chance to get up to speed on this case.
All right, I'll set Ms. Thompson's pretrial then on November 9th. And we'll run the cases on the even date.
Yes, sir, that'll work.
And is online discovery turned on for Mr. Stevens?
Yes, Judge, it does appear as though it is.
Yeah.
And is there any digital evidence that he needs to obtain?
Judge, it appears there are 9 DVDs. I show that they were copied once. I don't know if Mr. Knoll has it. If Mr. Stevens will let my office know, we will make sure that it is available for him as well at his earliest convenience.
I do not have the disc.
So it's going to be important to get over there pretty soon to get those, since there's 9 of them. There'll be a lot of content on there you have to review prior to 11/9 to make a decision on if there's any contested pretrial motions.
Yeah, absolutely.
All right, court will adjourn in this case until November 9th.
Thank you, Your Honor. I appreciate it, sir. Again, apologize for not being able to be there in person.
And have you visited with Ms. Thompson in person, or do you have plans to do that?
I have visited with her in person once, Your Honor, and I plan to go back and see her.
Okay. All right. Ms. Thompson, we'll see you on November 9th.
Thank you, sir.
All right, Mr. Stevens, is that all you have?
Yes, sir, it is.
Whose court are you in today?
I'm in Judge McKee's, and I had that we thought of the, and I was going to get out of here, but you know how these things work out at the last minute. It ended up being a plea, and I'm still here working on it.
Okay, well, tell him I said hello and let him know how easy it is to appear in my court.
I'll let him know you're going to hold me in contempt, Your Honor, because he wouldn't come in.
Yeah, you do that, and I might actually hold you in contempt.
Yeah, you probably would. All right.
Have a good day. You bet. All right, Ms. Heisel, any other Thompson with Mr. Gammons?
Yes, Your Honor. I have the paperwork. I'm ready as soon as they are.
Okay. And Mr. Ashmore, is he close on any of his clients?
I will check his status while we are handling this plea, Your Honor.
All right, Mr. Gammons, CR 2164. Ms. Heisel, can you tell me the terms of the plea?
Yes, Your Honor. This is going to be to a state jail felony PCS under Graham. State's recommending punishment be assessed at 2 years, TDCJ probated for 4. And sorry, Judge, that would be 2 year state jail division, probated for 4. Fine of $2,500, $180 in restitution, $290 in court costs, $960 in reimbursement fees. This also takes into consideration under section 1245, cause number 2021-00038, which is a misdemeanor criminal trespass. And Judge, I do not show that Mr. Gammons, according to this paperwork, is being awarded any time for his back time credit. But
Okay.
let me check.
And he's not going to be doing any additional time as a condition of probation, right?
That's correct.
Okay. So any credit time that he has on this case, he would get if he's revoked and sentenced. So, okay.
That's correct.
All right, Mr. Gammons, if you'll raise your right hand, sir, I'm going to place you under oath. Mr. Gammons, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you can put your hand down. Mr. Gammons, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
And have you ever been diagnosed with any type of mental condition?
No, sir.
And in this case, you're represented by your attorney, Ms. Ann Thompson. Are you pleased with her representation of you?
Yes, sir.
Do you feel like you've had enough time to discuss your case with her and have all your questions answered?
I mean, as far as I know, I signed for, as far as I know, I signed for 4 years probation. Is that correct?
Correct.
Okay.
Yeah. So,
I don't have no problem. She does her job really well, and the phone situation wasn't her fault or mine, so.
okay. All right. And so, Ms. Thompson, do you believe Mr. Gammons to be competent today?
He is competent, Your Honor.
And you've explained to him his legal and constitutional rights, and do you believe he understands them?
He does understand him, and we have had that discussion in person on September the 20th.
So, Mr. Gammons, you've been indicted with the state jail felony charge of possession of a controlled substance in penalty group 1, less than 1 gram. That has a range of punishment. If you were convicted and sentenced by either a court or a jury, the range of punishment that they would have to stay within would be some sentence not less than 6 months and not more than 2 years. The plea agreement that's been proposed between you and the state is that you would plead guilty to that charge. The state would recommend that your sentence would be set at the maximum 2 years, and that sentence would be suspended and you would be placed on probation for 4 years, and you'd have to pay all of the money that Ms. Heisel indicated, fines, court costs, reimbursement fees, restitution, and that they would be dismissing the, I think it was a criminal trespass case.
Sounds good.
Okay, is that your understanding?
Yes, sir.
Now, you understand that if I approve this today and you go on probation, if you violate your probation and the state brings you back to this courtroom and they prove to me that you violated, then the court could revoke your sentence and the court would assess your punishment at 2 years, the maximum 2 years in the state jail prison. You understand that?
Yes, sir.
Okay. Understanding the plea agreement and the range of punishment, Mr. Gammons, I'm going to ask you, how do you plead to possession of a controlled substance in penalty group 1, less than 1 gram?
I plead guilty, sir.
And do you plead guilty because you are guilty of committing that crime?
Yes, sir. Yes, sir. Most certainly. Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty?
No, sir, they haven't.
All right, court accepts the defendant's plea of guilt. Ms. Thompson, any objection to states 1 stipulation of evidence?
None at all, Your Honor.
All right, court admits states exhibit 1 and judicial notice of Mr. Gammons' judicial confession. State, will speak to the facts to support the plea at this time.
Yes, Your Honor, and just briefly also, I do see that I have Mr. Gammons' signature on these sets of paperwork. However, I don't have his thumbprint, so I will be driving these out to the Van Zandt County Jail to get that after the plea. Additionally, Mr. Gammons has not signed the conditions of probation, which may be some of the confusion about the intricacies of his probation, but we all agree we're talking about 4 years probation here.
Okay, thank you.
And
Your
may I ask you a question, Judge?
Go ahead.
Now, as long as I do good on my payments, community service, anyways, within 2 years, now, is there any way that I could, I could hire a lawyer, correct? And maybe get it, deducted where I could get off probation a little earlier, as long as I'm up to date with all my payments and everything's all up to date. Is there any possibility on that, or am I going to just have to talk to my probation officer about that?
The law does afford you the possibility of early termination of community supervision when you need a certain period. Once you've served enough of your probationary period,
yes, sir.
The law does afford you the right to ask for early termination of your community supervision.
Sounds good.
You can do that on your own, or you can hire an attorney to do that. But yes, you are correct in that respect.
Sounds good. Thank you.
Go ahead, Ms. Heisel.
Thank you, Your Honor. Mr. Gammons, the sheriff's office was dispatched to a suspicious person who was throwing items at vehicles. The sheriff's office responded, and they observed a gentleman who they came to know as Mr. Gammons, standing between two open doors of a vehicle on the side of the road, essentially kind of shielding himself from view. As soon as officers arrived on scene, Mr. Gammons ducked into the vehicle. They then saw an object fly out of the front the front driver's side window, land on the ground. They detained Mr. Gammons, went and looked, and it was a pill bottle that had 0.12 grams of methamphetamine in it. Mr. Gammons on scene denied that was his, but again, the officers saw him get rid of that in plain view.
Ms. Thompson, any objection to that summary?
No objection to it, Your Honor.
All right. All right, then, Mr. Gammons, anything further from the defense, Ms. Thompson?
No, Your Honor, we're ready to close.
All right, then the court, based on the evidence presented, finds that there is enough evidence to convict Mr. Gammons of this offense. The court will convict him of possession of a controlled substance in penalty group 1 less than 1 gram. The court will assess his sentence at 2 years confinement in the Texas Department of Criminal Justice State Jail Division. The court will suspend that sentence today and place Mr. Gammons on 4 years community supervision. Order him to pay a $2,500 fine, $180 restitution, $290 court costs, and $960 reimbursement fees. The court also dismisses under section 1245, cause number 2021-00038, a criminal trespass. Mr. Gammons, you're hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence.
Yes, sir.
I want to make sure that we get his fingerprint before he's released on that judgment.
So I have to report before 5 o'clock, correct?
I believe Ms. Burns or Officer Mature is there. Is that right, Aaron? Okay. One of the officers there are there from the probation department. They'll tell you what you need to know.
Thanks, sir.
All right.
Thank you, Ms. Thompson.
You're welcome, Billy.
Thank you, Ms. Thompson.
Yeah, that's all I have. Thank you.
You're very welcome. Yes, ma'am. Good to see you. All right, Mr. Ashmore, I think he's the only one remaining. With 3, Dover, Foley, and Cannon, right?
Yes, Your Honor. I've summoned Mr. Ashmore. We have 2 of his 3 clients, and the 3rd one is on the way.
Okay. I'll give him 8 minutes. Mr. Ashmore, are you ready?
Yes, Judge, thank you. Sorry about the delay.
Who are you ready on first?
We'll go on Miss Dover.
Ashley Faye Dover, CR 2159.
Your Honor, we're here on a plea for Miss Dover.
Okay, what are the terms?
Judge, this is a state jail felony alleged to have occurred on November 26, 2020, possession of controlled substance, penalty group 1. The terms of the plea are finding of guilt deferred, punishment 3 years community supervision, fine of $3,000, $180 restitution, court cost $290, reimbursement fees $585. Standard probation conditions, I've explained all those with my client, and 210 hours of community service. And she understands the benefits and the advantages to a deferred and the disadvantages to the deferred about how the punishment range is open to her. We've discussed all those things and we're ready to proceed, Your Honor.
Thank you, sir. Ms. Dover, please raise your right hand, ma'am. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Your name is Ashley Faye Dover, is that right?
Yes, sir.
And Ms. Dover, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Ever been diagnosed with any type of mental condition?
Yes, sir.
And your attorney is Mr. Casey Ashmore. Are you pleased with his representation of you?
Sir.
Do you feel like you've had enough time to discuss your case with him and have all your questions answered?
Yes, sir.
Is there anything about the paperwork that you've read and signed today that you do not understand?
Yes, sir.
And Mr. Ashmore, I'm not sure if you said it or not, do you believe her to be competent today?
Judge, I do believe my client to be competent.
All right. Ms. Dover, the range of punishment for a possession of a controlled substance charge that's a state jail felony is confinement in the state jail division of the state prison for not less than 6 months or more than 2 years, and a fine not to exceed $10,000. If the court approves your 3-year deferred adjudication plea, if during your community supervision period, if you violate and that's proven to the court could adjudicate your guilt, which means could convict you of the possession charge, and that would make you a convicted felon for the rest of your life. And the court could also revoke your probation or your community supervision and could place you in the state jail prison for anywhere between a minimum of 6 months to a maximum of 2 years. Do you understand that?
Yes, sir.
So understanding the range of punishment and the plea agreement in this case, how do you plead to that charge? Are you pleading guilty because you are guilty of committing that crime?
Yes, sir.
Has anyone threatened or forced you to plead guilty today?
Yes, sir.
Court accepts the defendant's plea of guilt at this time. Mr. Ashmore, any objection to States 1 stipulation of evidence?
No, Your Honor.
States 1 is admitted and the court takes judicial notice of the defendant's judicial confession. State, can you give me the facts to support the plea?
Yes, Your Honor. On the date in question, November 26, 2020, Grand Saline Police Department pulls up upon a truck with a trailer that is broken down on the side of the road and goes to assist. They notice that the license plate on the truck does not match the registration and that the trailer's registration is expired about 10 years prior. Grand Saline officer asked for consent to search the vehicle, is given consent by the driver and the passenger, which is Miss Dover. She states that the black box in the back is hers. And during the search inside that box, he finds 0.24 grams of meth, which she then claims. The driver is also arrested for possession of marijuana and the possession of a dangerous drug.
Any objection?
No, Your Honor.
All right.
That's
Then,
my understanding.
okay, then based on the evidence presented to the court will find that there is sufficient evidence to convict Ms. Dover of this charge. The court will follow the plea agreement in this case and defer a finding of guilt and place Ms. Dover on 3 years community supervision. Order her to pay a $3,000 fine, $180 restitution, $290 court cost, and $585 reimbursement fee. Ms. Dover, you're remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. I'm going to have you step over to be fingerprinted. After that, I want you to report to the probation officer there in the room and she'll give you further information.
Thank you, Judge. Mr. Cannon is ready, Your Honor.
Mr. Cannon. CR 21-282, State versus Justin Lee Cannon. Mr. Cannon set for arraignment. Do you have that indictment there with you, Mr.
I
Ashton?
have it, Judge, so I'm gonna grab it. Spelled correctly. Understand the allegations alleged to have occurred on that day. So, there's no expert here. Understand that? That's the case. 2014. Judge, my client has identified that his name is spelled correctly on the indictment and that he understands the nature of the charges against him, that they are alleged to have occurred on March 29th, 2021, that there was an allegation of imminent bodily injury, brandishing of a deadly weapon, and that there is an enhancement. He has authorized me to enter a plea of not guilty at this time. and work with the state of Texas to resolve this matter. So we are formally waiving the need for reading the formal indictment and asking the court to enter that plea and reset us for our pretrial hearing.
All right, court will enter Mr. Cannon's plea of not guilty into the record. Court will set pretrial in this matter on November 30th at 1:30, as long as Mr. Cannon is in jail. If Mr. Cannon makes bail, his case will be heard at 9 a.m. in the courthouse.
Thank you, Your Honor. Can he have a seat for a moment, Your Honor?
Yes, yeah, we're adjourned in his case.
Judge, we're ready on Ms. Foley.
All right, Lauren Foley, CR 21282, I'm sorry, 262. And she is set for pretrial.
Hi, Your Honor. I have received the majority of the discovery. That's I think maybe the totality of it. There might be a few other things not yet in the state's possession. These have all raised some issues that I've brought to the state's attention. And I am going to ask the court to reset this for another additional pretrial, because having just got the medical records in this case and learning more details about the allegations, I think that there may be one or two pretrial motions that the court needs to consider. My client's mental health may have been a factor in this matter. In addition to that, we're going to ask the court for a bond reduction because she does have an active CPS case, and she needs to at least have the court consider the opportunity for her to work services. I was not aware that there was an active CPS case previously. That's on me, but regardless, I'm asking the court for that leave of court to have one additional pretrial. I don't believe the state will oppose that, so we can work through these issues. I don't think the state will agree to all the relief I'm requesting. I'm just asking the state to at least consider agreeing for a second hearing so that these things can be presented.
Your Honor, the state has no objection to another pretrial. Mr. Ashmore and I had discussed a bond reduction. It appears that Ms. Foley's bond is currently set at $25,000. We were both under the impression that it was a little higher than that. And so at this point, we wouldn't be in agreement, but if Mr. Ashmore would forward that to us for a hearing on another day, we could potentially come to an agreement or have a hearing on that.
Any objection to his request for an additional pretrial?
No, Your Honor.
Would November 9th give you enough time, Mr. Ashmore, to make your pretrial filings?
I believe it would. May I just check the calendar to make sure I think I'm here, but I want to double check, Your Honor.
Yes, sir.
And I apologize about being delayed. I had a Zoom pretrial hearing, which was delayed, and that delayed me here. And it's the world we're living in, Judge. I apologize. Judge, that date works.
Okay, we'll set Ms. Foley then for November 9th at 1:30, 9 a.m. if she makes bail.
Thank you, Judge. That's all I have. May I be excused, Your Honor?
Yes, sir. Thank you, Mr. Ashmore. Good to see you.
Good to see you. Thank you.
All right. Unless Deputy McLeish, you're aware of any other people who have not been heard on this afternoon's docket, I believe that we are concluded for the day.
I agree with you, sir. I believe we are as well.
All right, then we'll be at this time.